Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to talk about lack of testamentary capacity in Iowa will contests. So first, let's talk about what a will contest is. A will contest seeks to hold a will to be invalid. There's lots of grounds for a will contest, lack of testamentary capacity being one of them. But in order for a will to be valid, it has to be signed by someone with testamentary capacity, meaning that they're of sound mind at the time that they sign the will, in the presence of two witnesses who contemporaneously sign the will. And everyone has to be of sound mind, and everyone has to be over the age of 18 when that happens. If any element of that is missing, then the will can be held invalid, and instead any prior will take effect, or state intestacy statutes. An intestacy statute is a statute that lays out what happens if no will exists and who inherits what. So that's what a will contest is, and lack of testamentary capacity is one of the most common grounds for a will contest. So in order to have testamentary capacity, be of sound mind to the extent that you can execute a will, it's not the same as being of sound mind generally or being free of any mental illness. Three things have to be true at the time that the will is executed in order for someone to execute a valid will. One is that the person executing the will, known as the testator, must have the ability to understand the property that they own in detail. Number two is that they have to understand the natural objects of their bounty. So what does that mean? That means children and other immediate family members. They have to know who their children are, grandchildren are, and other immediate family members are. And who's alive, who's not. Finally, they have to understand what a will is and how its terms will work to dispose of their property when they pass away. So if someone understands those three things, they have testamentary capacity and they can execute a valid will as long as they do so in front of two witnesses. The witnesses may be called to testify that they believe the person to have testamentary capacity when they executed the will. So that one of the reasons you have witnesses is to observe the person executing the will to make sure that they are of sound mind. So if you believe someone executed a will when they weren't of sound mind and did not have testamentary capacity, how do you prove that? There are three basic ways. One is mental records showing diagnoses of conditions that impact mental capacity. Things like Alzheimer's disease or brain damage from an accident. The second is expert testimony. So this might be the testator's nurses, doctors, or other medical professionals that actually worked with the testator, or it could be third-party medical professionals who never actually treated the testator, but can examine the medical records and say, yes, someone with this stage of this particular mental illness or mental condition would not be able to understand the three things necessary in order to execute a valid will. Finally, you can use non-expert testimony. So these are people who knew or witnessed the way the testator was behaving and can testify as to their opinion of the testator's mental capacity. Now, what's really important here is the timing. So if someone executes a will and then becomes mentally incompetent, the will is still valid. So you have to be able to show that at the time that the will was executed, the person executing the will lacked the mental capacity to legally do so. So if you have any questions, you can leave them in the comment section below this post at learn-about-law.com or below the video on our YouTube station. If you need some help, please give us a call, 563-503-6910. That's 563-503-6910. We offer free consultations in many areas of law. We have several geographic locations for your convenience. If you found this helpful, we'd love it if you'd subscribe to us on YouTube, SoundCloud, Apple Podcasts, or wherever you listen to your podcasts or watch your videos. Thank you so much for watching and listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.